Welcome to A Case for America. This is Austin Hepworth here with Michael Hepworth, and we are here today to talk about the Seventh Amendment along with the bigger picture of America in general. We love America and love what it stands for, and so we enjoy going through looking at the different provisions that have helped make America what it is, and then to have a conversation about whether there are things that should be changed, whether things are working good. And what our responsibilities as a people are. We strongly believe that law is necessary to a certain extent, but that we have to, as a people, step in and have morality. We have to do things ourselves without requesting that the law do everything for us. If we ask the law to solve all of our problems, we're asking for a state of tyranny. So today with the Seventh Amendment, we will read the text to start out. And it says, in suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. So mainly, people view this amendment as being one about jury trials in civil cases. We did look before in a previous episode about a little bit about jury trials in criminal cases. And so the Constitution talks about both civil jury trial in civil cases and a jury trial in criminal cases. Now, it's a little funny because it talks about the $20 in 1791. Today, that $20 would be almost $700 according to inflation indexes. But it didn't state inflation in it anywhere. So we're still in $20. If you have $20 or more in dispute, you have the right to request a jury trial, which I don't know if you can imagine being a juror and getting called to a case where there was $25 in dispute. You'd probably be pretty frustrated by that. Now, with how expensive trials are, that doesn't usually happen either. Usually there's a economic cutoff naturally where people won't sue for less than a certain amount. But it's a possibility in theory. But again, for the most part, the money limit is well exceeded today. Most people don't go to trial over $700 unless they're in small claims. And small claims courts often don't have jury trials in them because you can choose to file in another court. And so we have this question kind of looming in America. There's, in looking at it in preparation for today, there's actually a fair amount of discussion on both sides. Some people want to do away with juries in civil cases, and some people want to reinstill and get more juries involved in civil and criminal cases because they feel that it's problematic with how few cases are being tried by juries. So Michael, I think you have some info on the number of cases and kind of the change over the years with the number of jury trials taking place.
Yeah, it's changed quite a bit, and there's been some studies out about it. So there's some decent numbers around it. If we look at what we're seeing today, or this study came out about 2021, we're seeing at the federal level, this is for criminal, but we're seeing similar, similar patterns for both criminal and civil cases. But today, less than 2% of federal criminal cases go to jury trial. Back in 1962, it was about 5.5%. So it's decreased quite a bit over that time. We're looking at number of trials, and while we see the number of lawsuits kind of rise and fall a little bit over that half century up till today, it stayed relatively flat. So there is a good decrease of the number of trials that are going to jury trial. I say the number of trials, I'm sorry, the number of lawsuits that are going to jury trial. And there's a number of reasons out that individuals like to look at. Some of them being, let me pull this up here. The eliminating things like they're talk about the damage caps that are placed on trials. You can, if you take something to trial, sometimes you can only ask for a certain amount. Mandatory arbitration. Sometimes you can't take it to trial because you've signed a contract that says you will take whatever disagreement you have through arbitration. Sentencing guidelines sometimes make trials not as attractive or prohibitive. And then there are mandatory minimum sentencing depending on what is being brought to trial. There's a lot of factors in this. I think we can say that the number of civil cases involving disagreements between parties has probably increased between 1962 to today. If you look at things like lawsuits between HOAs and members of HOAs, obviously far larger today than they were in 1962. So civil cases regarding those kinds of things have increased quite a bit. And in many cases, there's a large incentive to settle out of court given the cost of the trial versus maybe what you might have to pay in damages. So there's obviously arguments both ways, but the thought is it more fair? Should we go to trial? Should you be able to waive your right to trial? It's obviously decreased, and there's a lot of concern over whether that should be the case or not.
Yeah, it's an interesting spot because the complexity of trials, the cost of trials, that certainly has gone up over the years. As we have more and more laws, and as we have companies that get more advanced, they get better about hiding things, going through things. You look at, there's been trials that have lasted over 5 months, and jurors can be called in for 5 months, and they're expected to go through and dissect incredible amounts of information. One of the trials I was looking at, I think, had over 19,000 pages of transcripts from it because of how much testimony there was. And people without any formal legal training are being asked to go through it and solve these problems, find facts, determine whether there was a patent infringement, or determine who breached a contract first, determine if there was fraud present. And so just in looking at some of them to go through and give you an idea about, let's see, so this is a judge's statement. So it says, it was at the completion of one protracted civil trial. The federal district judge stated, quote, "Throughout the trial, the court felt that the jury was having trouble grasping the concepts that were being discussed. This perception was confirmed when the court questioned the jurors during the course of their deliberations and after they were discharged. When asked by the court whether a case of this type should be tried to a jury, the foreman of the jury said, 'If you can find a jury that's both a computer technician, a lawyer, an economist, an economist, knows all about that stuff, yes, I think you could have a qualified jury. But we don't know anything about that.' And that was in the case of Peripherals Leasing Corp. Versus International Business Machines Corp. back from 1978. Another one said that there was a major antitrust case, SCM Corp. Versus Xerox Corp. And also in 78, where 84 potential jurors appeared for jury selection. 22 of those had occupational backgrounds identifiable as relevant to the case. So they were managers, supervisors, scientists, or engineers that might be able to understand what was going on. All 22 were excused for cause, meaning the attorneys found a reason to get them out of there. They didn't want people that knew what they were talking about to be part of it. And so they ended up with jurors that didn't have any background in any of what was taking place. Another one in the Peripherals Leasing Corp case, there are 87 witnesses testified in the case. There were more than 2,300 exhibits admitted in a trial, so over 2,300 different pieces of evidence. The trial took 96 trial days, and this is the one that had the transcript of more than 19,000 pages. And so at the end of it, the jury couldn't agree on anything. They sat in deliberations for over 19 days and couldn't agree on what to do. Again, likely because that's a lot of stuff to go through and try and agree on. Another case they talked about was U.S. financial securities litigation. And there was, in this case, there were 18 separate cases put together for trial. And there were 5 classes certified, meaning there's 5 different groups of people represented in it. There were 20 individual defendants and 80 corporate or partnership defendants. And many of these defendants filed cross claims against each other. So in trying to track these things, there was 100 people on the one side being charged with stuff. And it's, again, a very complex case. They're not all this complex, but it certainly happens at times. Another quote from Chief Justice Berger. He says it borders on cruelty to draft people to sit for long periods of time trying to cope with issues largely beyond their grasp. Even Jefferson would be appalled at the prospect of a dozen of his yeomen and artisans trying to cope with some of today's complex litigation in a trial lasting many weeks or months. So these are some of the things that make people say that we should do away with jury trials. As they say, it's not right. You can't, get these people together to go through antitrust litigation, monopoly, fraud type litigation. If you look at Donald Trump's civil trial currently, his companies are being charged with $250 million fraud. And the jury's going through, listening to all kinds of evidence, listening to people. I can't imagine how intimidating it would be to sit on a jury, charging a former president with a crime, and to sit and listen and go through things. And these are pieces that, again, I think it's appropriate to ask, are we better off still with a jury or not? And to me, some of the factors we have to look at are, well, not every case is that complex. Are there things we can do to make complex cases a little more reasonable? One of the things that some people have suggested is calling a specialized jury, where if it requires special expertise, that all jury members, are brought in that have that expertise. And it's something the law is starting to look to do, to specialize courts, to create specialty courts. Delaware, for example, has specialty courts that are just for business disputes. Utah just barely created the same courts this last legislative session. I think they'll roll out in 2024. And those courts actually don't permit a jury if you both agree to be in them. Here in Utah, it's called a business and chancery court. If you have a dispute over $300,000 business to business, you can opt to file in the business court. If you get sued in the business court, you can either at that point request that you be removed from the business court if you want a jury trial, or you can stay in the business court and waive your right to a jury trial and have a quote experienced judge in business go through and decide things. And many people view that as a great step forward. I personally have some reservation in that, to me, one of the reasons for a jury is to make sure that real life's considered. Sometimes when we're just in front of an expert, they kind of lose sight of life or a lot that takes place. I look at the COVID experts, for example, that say, oh yeah, the way to stop COVID is to shut everything down. Again, you can argue about whether that's good advice or not, but let's just pretend for a minute that's true advice. there's still so much collateral damage. There's so many people impacted by that, jobs, youth with schooling, all kinds of things. And to me, when you're a jury and you're untrained in something, there is a piece of you that checks how it measures up with real life. But sometimes I feel that when we're experts, we get hyper focused on something and lose sight of everything else that's involved. But Michael, I'm curious to know your thoughts kind of for or against juries in complex legal disputes.
I'm kind of interested in the complexity because I don't feel if a law is something that should apply to everyone equally, that complexity is actually fair in that regard. I understand that business disputes, we've kind of raised businesses to the level of an individual in many cases, and that businesses are taken to court and businesses pay taxes and things like that. It creates a lot of complexity, but I think if we're all going to be subject to a law, it should be something that is understandable. And so I think we should look at some of what we're asking the law to do and maybe say, can we pare down the complexity a little bit? I'm of the same idea that I think it's good to have a trial by jury to be seen by peers in the community, people in the area, people attached to day-to-day, as you mentioned. And if we have made the law try to litigate things that people can't understand, we may be reaching. If it's illegal to trying to think of a good example with something like calculus, to derive a fraction or a function one way versus another way, and the only way to determine if somebody did that or not is to know calculus, I think we've overstepped with the law. And so when we make these things really complex between companies, did they or did they not fraud or defraud or whatever the case is, sometimes I wonder if we're asking the law to do too much, and if we need to stop and think about what we can expect from individuals, what they can be expected to live up to. If I'm going to be subjected to a law, I feel like I should be able to understand it. And I think that in society, there's a large range of ability to understand. And if we're looking to prosecute every single wrong that ever may happen, we might be getting so complex that most people just don't understand it. And that is a little concerning to me.
Yeah, and I think that's a good point to look at. Are we asking the law to solve too many things? Are we asking it to reach down through too many layers? Because certainly, if you need 87 witnesses to prove someone did something, that gets really interesting. And certainly in the financial crimes realm, so we're talking Wall Street type things. If you look at Sam Bankman-Fried, I think his name is, the crypto guy that is alleged to have defrauded investors. It's pretty interesting to look at where he was at, look at the sheer breadth and scope of how much money there was, how many layers there were to things. Because they would make representations to investors, and then at the end of the day, the company fails. And as the government digs in, they say, oh, well, you were doing this and you promised you wouldn't. And they'd say, oh, well, it was, in this fund or over here or whatnot. And as I look at situations like that, and also things like Apple, the EU is really frustrated with Apple, the European Union, because Apple doesn't really pay taxes, even though it makes so much money. And it's got this really cool system in place that were set up by its attorneys. I'm sure it cost them, I would guess, tens to hundreds of millions of dollars to set up. But they have set up so many layers to things and so many entities, and put so much paperwork in place and documentation in place that all their money kind of goes to, I think it's Ireland. I forget if it's Ireland or Iceland, one of those. And they have a tax treaty with them that says they won't tax them. And so all this money kind of flows there, and they move it, and at every step, it's technically legal in nature. And again, it's great attorney and accounting work. But tons of money goes there and they're not paying taxes in the EU. So the EU looks at it, and I was very interested by the EU's response because they looked at the complexity, they looked at all the levels. Apple, I think, had actually done a very good job, from what I could tell, of checking all the boxes, making sure everything was legal at every step. But the EU couldn't unravel exactly what was taking place. So they went to, again, it was either Iceland or Ireland, and ordered them to go collect from Apple. Said, you're breaching the member duties to kind of make sure you collect your fair share and pay your fair share, and you're not doing it with this tax treaty. And then they left the country to decide what to do at that point. But I look at that and go, yeah, it's interesting when there's billions to trillions of dollars. People can pay to make things incredibly layered and incredibly complex. It could still be fraud. Now it's just funneled through so many layers. And so it is one of the funny things. I agree, and large part of what you're saying of, complexity is maybe a sign we're trying to bite off more than we can chew as a legal system. But in some ways too, it's showing just the sheer amount of money out there and how complex people will make things to try and avoid scrutiny.
And the amount of money is an interesting thing to talk about. I was looking up average litigation costs, and I just found a study that looked between 2000 and 2008. So we're talking quite a while ago still. But they were reporting increases of some 73% in litigation costs to businesses from 2000 to 2008. So they were increasing from some 66 million to 115 million. Other areas saw increases of 112% over that same time period. And if you think 2008 was a high point, it just continues to grow. So to own a business, people sometimes get upset with businesses and how much money they show in revenue. But if they're going to be on the hook at any point in time for massive amounts of litigation, they're really doing a lot to try to cover their bases. And we should wonder as a society if our increased effort to pursue more and more of this money isn't just creating more and more issues, in that litigation costs are going up like crazy. So that means that the costs to the end consumer are going to go up for any business that has to engage in litigation. And when the amounts are this large, that is a lot of money that we're pursuing. And in the end, for what? If it costs that much to go get it, are we making anything from it? Are they doing anything differently? No. Typically, they just use these big companies will just pay more lawyers to do different things, raise their litigation costs, and continue to make money. And so we may be pursuing something that we can't really get, or things are just so complicated at the way we're trying to get money. For every step we take to get more money, a company will invest more money so they don't have to pay it. It will just continue to be that way.
Yeah. And it is one of the problems with, so this is something to note about America. And one of the ways it's opted to police its laws is it specifically creates what's called a private right of action or private cause of action that allows people to sue to enforce the law. And then what that does is it makes it so there's a capitalist type incentive for lawyers to sue and sue and sue, because they can make money off of it by enforcing these laws. And the reason that the government puts in these private causes of action is because then they don't have to go after it. They say, oh, this is limited government. We're not having to enforce every law. If something happens, we don't have to be there looking over everybody's shoulder, and just private parties can go to court. If the law is broken, the judge can agree or the jury can agree, give them money, kind of thing. And what we're doing is we're commercializing the enforcement of law with these private causes of action. The law, for the most part, I believe, should be enforced by the government. It's one of the checks and balances in place of, if you're going to create a law of government, then it needs to be something that you can handle tax-wise. But if you then say, oh, hey, guess what? If you know someone not paying taxes and you sue them, we'll give you 40% of it. Um, we've now have mixed this financial incentive with pursuing, you know, the law or enforcing the law or whatnot. And it creates very perverse incentives, and it really starts to lead to this breakdown in society where you can't trust anyone because everyone can make money off you. They can sue you and have a personal benefit for it. It's not even that, oh, I sued you to enforce a law, and instead of paying me, it goes to, maybe the law could be that it goes to a fund to help people who are, been injured in war, who knows what. Or maybe it just goes to the government to help pay down the national debt. Why not? Um, but instead it goes to these private people and it goes to the attorneys, and there's businesses out of it where even now there's law firms that make apps even to help you identify when you might have a case or a cause of action. If you're getting called by numbers that you shouldn't be called by, an app can track that and get your case ready and do all kinds of things. They have people that go out and try and find violations of the Americans with Disabilities Act, where if a business doesn't have everything just exactly right, maybe they're a few inches off on measuring something or whatever else, there's people checking into that and notifying law firms of companies they can go after and sue. And it's a business. And as we have to remember that things like war, we look at war, it's really sad right now to see Israel, Hamas, Russia, Ukraine, Syria. So some places have been at war a very long time. We don't talk about them much, but people make an incredible amount of money off of war. And America is also going into its penal system, and it's allowing businesses to operate jails, and they get paid per person that's in the jail. So they make money if there's people in jail. America has the highest incarceration rate of any country. We incarcerate an incredible number of people. And yet there's businesses that make more money when there's more people in jail. These are perverse incentives. I don't believe that money in government and money in law should always mix. And they have with these private causes of action. And it leads to some crazy type results, including even with, there's a type of damage in law, and this is one to talk about with juries, called punitive damages, where a famous example of punitive damages was the McDonald's coffee case, where a McDonald's lady put coffee between her legs. She was driving, it spills out, burns her really bad. And as her attorneys look into it, they realize McDonald's has received thousands of complaints that its coffee is just way too hot. And McDonald's basically said, yeah, we don't care. We essentially nuke it. We know it's crazy hot, but for most people it works because it takes them a little while to get to drinking it. And we want it to still be hot when they drink it. And so the jury, in looking at this woman's situation, they look at 1,800 people that had been injured by McDonald's coffee before this because of how crazy hot it was. And they saw that McDonald's didn't care. They weren't stopping. So they give the lady her damages for the burns and things she received, medical bills, whatever. And then they awarded her a bunch of money in punitive damages, which are meant to penalize McDonald's to make it so they won't do it again because of how much it costs them. And what they chose for the number of punitive damages was 1 day of coffee sales for McDonald's. And they said if McDonald's loses that much money every time someone gets burned, they'll stop doing it and they'll make their coffee a little safer. Now again, is that the right decision from a jury or not? This is one of the interesting things is juries can often be swayed to award very high amounts of punitive damages. And a recent case this year from Riverside, California, had a woman who was abused, sad situation. She was abused by her stepfather. And once she became an adult, she sued. And she sued her stepfather for the abuse. She sued her mother for knowing about the abuse and not doing anything to stop it. And she sued the bishop of the local church because she alleged he knew about the abuse too and didn't stop it because the dad had gone and confessed, was the allegation. This was a case in Riverside, California, and the church involved in the lawsuit settled a little before trial for $1 million on a situation where they didn't actually do anything. They didn't do the abuse. They weren't the abuser. It's just an allegation that they knew and didn't stop it. And the girl was able to convince the jury, her attorneys were able to convince the jury to award basically $2.4 billion in damages, both actual damages and punitive damages. Actual damages, the jury felt the girl had actually been damaged over $800 million from the abuse. Now, I'm not here saying abuse isn't a horrible thing. I think it's crazy, horrendous, but I don't have any comprehension of how a person's life could cost $800 million. It's something that, um, even if you're in therapy every single day, getting help, I don't know where you came up with $800 million from. The jury did. They awarded another 1.6 billion or something in punitive damages to send a message that they don't want that to continue. And again, the church didn't end up being liable for that because they had settled. But if they're still in the lawsuit, they could have been on the hook for those. And the girl won't actually collect that money because her stepfather and mother don't have that much money. But those types of cases send a message to attorneys that, ooh, we get a jury involved and there's something bad that happens, some sexual abuse or something, we can convince a jury to award billions in punitive damages. And this is one point where I say we might need some checks on the jury system to some extent. Because if the jury can decide how much money to pay and it's full of a bunch of people that hate corporations or whatever, or churches or whatever they don't like, and they listen to this gripping narrative of someone that's been injured and damaged, again, those are bad things. But toward $2.4 billion, it's a pretty big stretch. And this is where, when we talk about jury trials going down percent-wise, people choose to settle because they know they get penalized if they don't settle. They know that there are these situations that the jury could penalize them and just throw out some number. It's anyone's guess as to what that number is. And so they have the cost of legal, which is very expensive, and then the uncertainty of what a jury can award. And to me, while juries are very helpful to establish facts, to say, yep, there's different pieces here, I do believe the law needs to have a balance, that there should be some predictability in what you can be liable for. And right now, awards from juries and judges they're increasing significantly, where companies are getting hit with bigger and bigger judgments, billions of dollars at stake, and way too much risk for a business to know what to do if they go to trial.
I think that's a really key point. If as a business, you don't know what to expect because number one, the damages might be horrendously high. And then on top of that, punitive damages supposedly is an attempt to convince you to stop doing it. Well, if punitive is so high that you just have to stop being a business at some point because you can't afford the risk, then what do we lose as a society if businesses just have to stop being businesses? They can't afford the risk of being a business because somebody might go after them for some damage. And this isn't to say that damages don't occur from businesses, but if a business is negligent in some way, and then in punitive fees, we put them out of business, what happens to our society if businesses can't afford to be in business because we seek such high punitive damages on them? Sometimes we look at it like, well, what is just? We need to go after justice for individuals that were injured. And I don't know that some injuries, I don't know that there is justice in this life for some injuries, meaning if something terrible happens to you, you were abused, are you really trying to say that some amount of money is the just compensation for that? I don't know that we can bring justice to an individual that was hurt like that. Not to say that we shouldn't go after and try to prevent harm, but to to try to pursue these dollar values just makes it so we can't function as a society anymore. We lose any ability pursuing some idea of justice that I don't know that we can get. I think we should just try to think about the cost both directions, cost to society and then the cost to individuals bringing forth legal action.
Yeah, and there's two things I want to bring up with that are real life examples. So in 2013, the federal government went after FedEx and UPS and alleged that they were helping to deliver pharmaceuticals to get, legally prescribed things to people. And this is a situation where people could order pharmaceuticals online from Canada or whatever. They were being delivered via UPS and FedEx. UPS and FedEx technically don't know what's in a package. They don't know if someone has a valid prescription or not. And UPS's approach to it was, well, there's a lot of risk in this. Who knows what the government's able to convince a judge or a jury of? And so UPS chose to settle for $40 million, pay a $40 million fine. And FedEx said, no way, we're not guilty of anything. We're not, assisting in delivering pharmaceuticals. If you want to go after a company that's selling drugs illegally, go after them, not us. We're just a delivery guy that delivers packages. And they chose to fight it. And they went, challenged it. Well, the government, in the case where FedEx chose to fight it, demanded a $1.6 billion judgment against FedEx. That's what they sought. So they went from 40 million with UPS for the exact same thing to $1.6 billion. It went up 40 times what they were seeking because FedEx chose to fight it. Ultimately, FedEx prevailed and didn't have to pay anything other than their attorney's fees. But they have what's called a trial penalty. And some studies have articulated that on average, in a criminal case, people will go to jail for 3 times longer if they choose not to plead guilty and choose to try and defend their innocence at trial. And they have, the number of years of those who pled guilty versus the number of years that someone was sentenced. And this goes back to what Michael talked about at the start of the mandatory minimums. It will say, oh, the mandatory minimum for a felony is 15 years in prison. But hey, if you plead, we won't go after you for a felony. We'll give you a misdemeanor, and you can only serve 5 years in prison or 3 months or whatever they offer them. And to me, it's a very problematic situation when we have these plea deals and these potential settlement offers where you can get such a better deal if you just work with us and admit you're guilty. And there was a study that said that I want to say, so 300 or 500 some odd individuals who were found innocent via DNA evidence. So they'd been convicted and put in jail and were later found innocent. 11% of them had pled guilty because they were so afraid of the bigger penalty associated with if they were still found guilty at trial for something that once the DNA evidence came out after the fact, there was no way that they could have done it. These people were innocent. So it produces this scenario where there's big risk. And again, from a jury perspective, are we managing this? Are we allowing people to settle for one thing or plead for one thing, but then the penalty goes up extensively where they seek way more against you? It's fairly concerning. But the second piece, and this is just, I know there's, we talk about a balance in America, and the legal system has tried to balance this some with punitive damages. And we talked a little bit before about maybe how a business or an individual should know how much they might be liable for with something. Well, that was kind of the norm for a while, where a business could they could understand what something would cost. And so Ford had a situation where they had the Ford Pinto, and the Pinto had a design defect where there was a big bolt kind of towards the back of the car, and the gas tank was kind of towards the back of the car. And if the car was rear-ended, even just in a low speed rear-ending accident, this bolt would puncture the gas can and it would explode. And so the Pintos started to explode, of just even, again, pretty low impact car rear end type accidents. And Ford had actually discovered this, and they discovered the issue. They fixed it on cars moving forward, but they were trying to decide if they did a recall or not of the existing Pintos. And so they actually ran the numbers and said, well, it costs us, X amount per life lost. So even if people die in the fire, this is how much it will cost us per life lost. And statistically speaking, a Pinto is going to be in X number of accidents. And they ran the math and determined it was cheaper to pay for every life lost than it was to recall and fix the existing Pintos, because they knew exactly what it would cost. And so at trial, this memo that had circulated was presented, and the jury was quite upset, understandably, that they chose money over lives. And so the jury hit him with significant punitive damages to say, we're going to make it so you never want to elect to, run a numbers calculation based on a situation where people are dying. You should just fix your car no matter how much it costs. And so I share that as just kind of when we talk about the balance. The problem with people knowing what things cost is that they can then budget for it, and they choose money over morality and lives. And so far, the legal system awards punitive damages as a measure of how best to manage that. And we haven't really come up with a better way to balance that. And so we still have this situation in America where punitive damages can be awarded, the jury can award them, and where companies can be terrified of that, choose to settle, like UPS, even if they're not guilty. And it produces, from my perspective, a situation where we're a little out of balance. And to really have liberty, we need to go back in and look at some of these scenarios to see what may be necessary to make it more fair and be able to handle the situations where you have Ford executives that choose just to let people continue to die because it's going to cost them a bunch of money to recall something that they did wrong. But that's some of the balance, I guess, of some of the issues of what we're looking at on both sides of this jury equation.
And to bring that to our lives in general, I think we need to remember that that's kind of a decision we all make every day, in that we balance safety, our lives, with money and experience every single day. So sometimes we get upset with individuals or companies that we feel are out of balance. In Ford's case, we felt like they should have taken better care of individual safety. But every day we make decisions that say, I'm going to risk some safety or some health here for this experience or this amount of money. We do it when we purchase food. We do it when we're going out seeking entertainment. It's something that is kind of natural to life here on Earth. And so we do need to remember we should be careful if we're trying to punish companies for doing something that we do. You can make a car that's a lot safer than most of the cars on the road, and we can mandate the way it's made. We would limit how fast it could go. It would look a certain way. It would be less efficient because it would be made more like a brick than it would be something that flows through the air, so it'd take more energy to move. But if all we were focused on was keeping people safe, we can mandate those kinds of things. And instead we've said, actually, we can have some give and take. We can say we can take a little bit off of safety. We will accept some risk in order to have vehicles that are maybe more efficient or maybe look cooler in some cases. And so it is something that we all make decisions on every day. The question is, what are the limits to that? And can we be careful in how we punish individuals or companies for making decisions that we all kind of make every day? Kind of back to the balance between how much are we asking the government to do versus how much are we asking ourselves to do? Can we take some responsibility ourselves for our own lives and our own safety and not ask so much of the government, and maybe just ask from the government where it's appropriate?
Yeah, and it's a great point that we're appalled at Ford, and again, I'm personally appalled at Ford. I'm not saying I'm not. Um, but there's I was out in my tree the last week hanging Christmas lights, and there's a risk to that, right? I was saving money. I didn't pay a professional to do it. I didn't rent a machine. I'm just climbing up the tree, and I'm up there 20, 30 feet in the air, and there is risk. And it was a calculated risk. I chose to take it. Now, certainly I wasn't putting someone else at risk in theory, but if I fell and died or something, my children would struggle and there'd be impacts to them. Um, and so we do have the ability to take risks and to make decisions. If I choose to ride a motorcycle or ride the bus or do whatever else, those are kind of on me. I can technically take the brakes off my car and still drive it. Um, and those are things I can choose to do. But to your point, we do that. All of us make a financial decision where something's not worth the money. It's so expensive that it's not worth the money. Um, and we may do some things that we just get lucky on or we regret later. Um, and it is necessary to recognize that there is a balance to that. And again, this isn't me advocating that Ford should necessarily be able to decide those things, but in discussing the principles even of the jury and where punitive damages come in, I do think there needs to be some principles that set some bounds at some level. I think that's what you're articulating as well, that there's the need to recognize that we as humans have risk. It's part of our calculus here on Earth. We can't get rid of all risk, and the sheer cost to get rid of all risk would put us all out of business. We wouldn't be able to afford cars, we wouldn't be able to drive, wouldn't be able to do things. And so, yeah, we do accept risk. We could eliminate virtually deaths in auto accidents by capping all cars at 25 miles an hour. But we choose that the convenience of going faster is worth the deaths that come. That's a decision we made as a society. I'm not saying it's right or wrong, but we have made that call. And so we can't sue the government for not putting things at 25 miles an hour. So, why should we be able to sue every company that might have a design defect? And these are good principles to ask about. What is the balance? When should we be able to hold someone responsible? When not? Um, and again, with juries, what is the balance there? Should the jury be able to say, oh, yeah, you get to make a lot of money, attorneys and persons suing, because you just happen to be the one that landed the lucky lottery, and we're going to award a bunch of money in punitive damages? I don't personally believe that there's any reason punitive damages should go to the attorneys or the individual. I'm a big proponent of putting punitive damages when they're necessary towards paying down the government's debt or something, make it useful publicly, because otherwise there's a financial incentive that creates a very perverse scenario when people make so much money off of it. And there are situations where people are highly incentivized to lie and exaggerate their injuries because of how much more money there is with it. One example, this is just a fun one to share before we're done here, but in Utah, a man was involved in a car accident. He sued, alleging that his back was all messed up, full of pain, all kinds of issues. And this lawsuit's going along, and the attorneys on the other side find out. He actually makes the news for this. He's in Goblin Valley, which is a place here in Utah where there's some formations where there's rocks kind of balanced on these columns and other things. If you haven't seen it, look up the pictures. The rocks are pretty cool looking. But they're these big rocks, boulder-like things that sit on these columns that are eroding away. And so the dirt underneath isn't as solid as the rock or the dirt on top, and it erodes away over time and leaves these things they call goblins. But you can climb on them, you can do things. That's allowed. But he was actually pushing them over. And so he's taking video of himself, and he's in Goblin Valley after he's sued, alleging his back's all messed up, can't do anything. And he's there pushing these massive boulders over, which is a criminal offense, because you can't destroy the things at Goblin Valley. And so the government gets involved, prosecutes him for that. But then the attorneys get a hold of it and are going, wait a minute, this guy's alleging, judge, that his back's so messed up that he can't even move, and he's here pushing boulders over in Goblin Valley State Park. And so to me, it's a reminder of the fact that when there is so much money involved, people are highly incentivized to lie. And that does happen in the personal injury world. How do you quantify pain? I'm in pain, I hurt. How do you disprove that? And so again, we've reached a realm, and especially with emotional damages, the juries are tasked to find, oh, how much were you emotionally damaged? Oh, $800 million worth. You know, we might say that's outrageous, but how do you quantify that as a person? How do you quantify how much money it takes to make sadness better? These are some of the realms where the law has gone into that it probably shouldn't have, because it's not quantifiable. Or if it is going into it, there needs to be some good checks and balances on it. And in my opinion, and I think this goes to one of your first points with juries, I believe strongly that juries are a great check and balance, very important, and that they get unwieldy in cases where the law has become unwieldy for the most part. And the law is asking a jury to determine things that people can't determine. And so it gets to be a little wild and unwieldy for the most part. Again, there are a few very complex technology cases or something that might get hard to follow. But for the most part, juries have done an amazing job. And I'm still a big proponent of the jury system. So I don't know if you have any further thoughts, Michael. Anything you want to finish with?
No, I think I just agree with you on that. I think we should try to push for a situation where we encourage jury trials, and because I think on the whole it's the more just outcome for everybody. And where they have their problems, let's address those. Let's address them to the point of keeping them instead of getting rid of them.
Yeah, because one thing we don't talk about, people will highlight the problems very quickly, but how do you quantify how much good they've done and how accurate they've been? You don't get cases where people talk about, oh yeah, the jury got it right here. But that's the cases we have that talk about juries with problems are very few compared to how many jury trials there have been. And I think that for the most part, the system works incredibly well. But one final note of interest with the Seventh Amendment, one caveat to know, states are not bound by the Seventh Amendment. So the original 10 Bill of Rights were written to only apply to the federal government. And technically, I guess the first 8, because the 9 and 10 they're a little different. But the first 8 only apply to the federal government's actions. When the 14th Amendment came along, that said equality for everyone, and the states can't abridge equality for people, the Supreme Court went through and evaluated each amendment to determine if the states were now bound by it because of the 14th Amendment. Almost all provisions in the Bill of Rights were incorporated to the states, but the 7th Amendment wasn't. So a state technically doesn't have to grant a jury trial in a civil case under the US Constitution. 47 states, though, have in their state constitution the right to a civil jury trial. But in theory, they could amend it, take that away, and there's no federal obligation based on the Supreme Court's interpretation for states to provide the right to a jury. So, random factoid there. But we appreciate you being with us today. And this next episode, we will talk about the Eighth Amendment and explore punishment, cruel and unusual punishment, death penalty, and a number of those issues. So thanks for joining us, and we look forward to being with you next week.